My name is Chuma Chinye, and I am your family lawyer. I was called to the Nigerian bar in 1988, and I have over 35 years' experience in family law practice. I've helped countless families navigate Nigeria's complex legal terrain, and I am desirous of bringing this knowledge and expertise to you free of any charges. My name is Chuma Chinye, and I am your family lawyer, your trusted guide through the legal landscape of family law. I am super delighted to welcome you to today's episode of your weekly podcast, Your Family Lawyer. Today's episode is a must watch. Trust me, you don't want to miss this one because we're going into a question that agitates many minds. That question is, why do I need a lawyer? Why do I need a lawyer to make a will? Why do I need a lawyer to prepare a trust deed? Why do I need a lawyer to plan what happens to my wife and children or my business? After all, a graduate, even a PhD holder, in business, a super medical doctor. Of course, you can prepare your will right inside your bedroom if you want to save money. But it is by far more expedient to pay a lawyer to prepare your will or your trust and to guide you through the processes. Because of the wise saying, a stitch in time saves 9. If you save money now by doing it yourself, DIY they call it, you may not be around to witness the enormous financial, the enormous emotional, and the enormous physical trauma that your miserly indiscretion might cause your family, for whose benefit you intended the poorly written or invalid will, or the shabby trust document that you knocked together from the internet. In spite of what I have said, why really do you need a family lawyer? Let's first answer this question as it concerns the making of a will by showing you the roles that a lawyer plays in your behalf from the onset, from when you begin thinking of making your will, and if the Lord tarries until you are gone to the land yonder. A good family lawyer will take time to understand your goals if you wish to make a will, your values, your concerns, and ensure that your wishes are accurately respected in the will and ultimately respected. It will help you to navigate the complex family situations, such as blended families and multiple marriages. And by blended families, we mean when you had been married previously, you had one child, and you marry a woman with 2 children. It could be a difficult one to manage. Your lawyer will advise you on how to navigate this and how to handle your business interests, including partnerships, your shares, and other investments. He will recommend regular reviews of the will to ensure that it remains up to date and reflects any changes in your circumstances, and assist you with updating the will to reflect the changes in your assets as they grow or dwindle, in your relationships as they go sour or new ones are acquired. For instance, you could marry a new wife, the wife could pass on, you could be in a divorce. A qualified lawyer will ensure that the will is valid, that the contents are effective, and that they reflect your wishes. It is difficult to imagine applying for probate without the assistance of a lawyer. A will is made because the maker of the will envisages that one day, he will not be there to enforce his will as he used to do when he was alive. When that dreaded time comes, the executors and beneficiaries invariably need a family lawyer to be a neutral arbiter, read the will, and to guide them through the technical processes of applying for probate at the High Court. And if it gets really bumpy, who best to litigate on your behalf than a lawyer, preferably one who has been involved in the processes from the onset? Next, we'll answer this question by showing you the roles of your family lawyer in the preparation and implementation of a trust. Remember a trust? The one who said it could be a viable alternative to making a will. A lawyer prepares it, and a lawyer will help you to review the documents, ensuring that they comply with relevant laws and regulations. The lawyer will advise you on the benefits and implications of creating a trust, including the tax implications and how it helps you to manage your business or protect your wealth. It is a lawyer that will assist you with the registration of the trust deed with the relevant authorities. It is also a lawyer that will represent your beneficiaries in trust-related matters in case a dispute arises, or to ensure that the beneficiary claims are in accordance with the trust as created. A lawyer provides you with the trust administration guidance, including trustees' responsibilities and beneficiaries, and ensuring that the trustees continue to act in utmost good faith. Remember, we said a trustee has to be trusted, but a lawyer can provide the services of a guardian angel, looking over the shoulder of the trustee to ensure that at all times they remain in the straight and narrow regarding your estate. A lawyer helps with resolution of disputes if and when they do arise in the administration of a trust. Of course, a lawyer could help you on planning the tax strategies to minimize liabilities and optimize the benefits of the trust. There is an issue that I would like to clarify, and so let's be clear about it up front. Your family lawyer, as it regards trusts, it would be unwise for your family lawyer to act alone and to do everything as regards a trust. To achieve desired results, your family lawyer should of necessity act in concert and in collaboration with your financial institution. Some of the ways that your lawyer could collaborate with your financial institution, your bank, for instance, is to ensure that there is a joint effort from the beginning in the creation of the trust and that everybody is on the same page. Lawyers and financial institutions work together to administer the trust and provide guidance on trustee responsibilities and beneficiary rights, and also regarding tax and regulation compliance. Of course, when conflicts arise, it is best if your lawyers are in tandem with your financial institutions, so they collaborate to resolve disputes or conflicts that may arise during the course of the administration of the trust. By working together, lawyers and financial institutions can provide comprehensive trust services, ensuring that trusts are created, that they are managed effectively to achieve the desired objectives of the settlor, that is the person who created the trust. I would like to issue a caveat here. It is unwise, on the other hand, to also deal solely with your financial institution. That is to say, whilst we have argued here that you should not use only a lawyer to create a trust, you should also not use only your financial institution. It's a joint affair. So it's unwise to deal solely with your financial institution, such as a bank or any of their subsidiaries, to bypass your lawyer and avoid their attendant legal fees. I'm saying this because it seems now acceptable practice for banks to incorporate subsidiaries that make and manage trusts, and even handle things like wills, some estate management services. Convenient as this may seem, it is only a win-win situation for the banks because it is usually a one-size-fits-all package, irrespective of your peculiar circumstances. It is indeed a penny-wise, pound-foolish decision to save money by not engaging an independent lawyer to interface with your bank or its subsidiary. And this is so because the bulk of the funds in your trust or your will are in the custody of the banks themselves. So please be wise. The banks actually provide good services. The consortiums that they put together have great minds, experienced hands, but avoid conflict of interest, that you have a lawyer also working on your interest in relating with those banks regarding your estates. Because when inevitable disputes arise, the maker of the trust and beneficiaries might be hamstrung because they did not have an independent solicitor interfacing with the bank or the bank subsidiary on their behalf. What I'm advocating is collaboration between the banks and independent lawyers at all times in the management of an individual's estate. It is good to work with a consortium with the bank, but also be sure your lawyer is always nearby. A family lawyer plays a crucial role in probate processes in ensuring that the deceased estate is administered efficiently and in accordance with the law. I just highlight as we begin to round up some of those activities. Just for emphasis purposes, the lawyer advises you on how to make your will. The lawyer will assist you with your estate planning and help you to minimize potential conflicts, ensuring smooth sailing administration of your estate when you are no more. As you watch in the videos or in movies often, you see there's a lawyer in a black suit that comes to the family and sits down, clears his throat. This is the last will and testament of Chief Sir Doctor. Now, from that point onwards, the services of a lawyer are invaluable, but you ought to have engaged them before, not after your death. Because when this time comes, they help you with filing probate applications. They help you in obtaining the probate. You can rest assured in your home while the lawyer goes through all the processes. It's their job. They are familiar with that terrain and they know what to do. And when you have a good lawyer who is competent and incorruptible, he will be the stabilizing force in your family because they will look up to him and be sure that what he's saying is what you meant to say. Now, many people don't think about this, but a lawyer could help you to gather your estates wherever they are located. It could help you to put them together and ensure that the things you named in your will are all that you have. And that when the time comes, your beneficiaries will be able to have access to those properties. And they can help you in managing your debts after you have died, ensuring that your beneficiaries are not shortchanged by your creditors. The role of lawyers in mediating conflicts cannot be overemphasized when it comes to estate management. Their role in litigating the disputes that arise, if they do, are also invaluable. You cannot begin to quantify that. So by engaging a lawyer, you can be sure that your probate processes are handled efficiently, that your trusts are administered effectively, and that the intention you had when you made a will or you created a trust are carried out to the letter. As we said earlier on, a stitch in time saves 9. Now let's quickly tell you a short story or two of what happens when you do it yourself. A certain Mr. Aderinoku wrote a will by himself in 2008. The will was ambiguous, open to multiple interpretations. He stated that his property should be divided between my daughter and my brother. His property should be divided between my daughter and my brother, without specifying which property or how the division should be made. Well, after he made the will, a couple of years later, he died in 2010, leaving behind his daughter and brother and other relatives. Now, they disagreed. This daughter and brother disagreed on what the man meant by my properties should be divided between my brother and my daughter. Of course, they ended up in the court. They went through the high courts. They went to the Court of Appeal. And at the Court of Appeal, the court said this will was ambiguous and unclear, making it difficult to determine what Aderinokun's intentions actually were. And the court said that the use of vague language, such as between my daughter and my brother, made it impossible to determine which property was being referred to and how it should be divided. Thus, the will did not provide sufficient details about the property, making it difficult to identify and distribute. So, what exactly were his intentions? Imagine if he told a lawyer, my property should be divided between my daughter and my brother. The lawyer would have put it in legal language and asked him clear questions. What property? How? Where? That didn't happen. Of course, the court could not determine what his intentions were. And so he achieved nothing with that will. His wishes could not be carried out. And of course, it was way too far gone to be asked what he meant. Ultimately, the court decided that the will was invalid due to its ambiguity and lack of clarity, and that his estate should be distributed according to the laws of intestacy. Imagine if he could see from where he was. He would quickly run back to get a lawyer, but he can't turn back the clock. He saved money, but he lost his will. It's essential, my brothers and my sisters, to consult a qualified lawyer to draft a will so that your will could be valid, enforceable, and reflect your wishes. Now, don't get me wrong, you can write your will by yourself. If you actually wish to do so, go to our website. You will see how to make a will, step-by-step guide. Trust me, when you get to the end of that step-by-step guide, my advice, click the button there so that you may well talk to a lawyer. Now, some other thing I've called regarding one Mr. Olowu, who also wrote a will in 2005. He did not sign the will in the presence of two witnesses as required by law. He couldn't because he did not know. The will was also not dated. He just wrote something. After writing it, he died in 2007. He left behind his wife, children, and his siblings. The siblings challenged the validity of the will, arguing that it did not meet the normal requirements of the Wills Act. Imagine the siblings who didn't own the properties knew the law more than he did. The court said that the will was invalid because it did not comply with the formal requirements of the Wills Act. Specifically, he did not sign the will. The law requires that he should sign it. If he had a lawyer, wouldn't the will be signed? He did not date it. It would be the height of negligence for a lawyer to prepare a will and not to have it dated or signed. And the will was written in informal language. I can't tell whether it was Pidgin English or Benin language that he wrote the will in, but the court said it wasn't in a formal language. It wasn't in a formal structure, and so wasn't a will in the first place. So in effect, we're saying that you're taking a big risk if you attempt to prepare a will or a trust document by yourself. There is no law that compels you to use the services of a lawyer. But as the Bible would say, all things are lawful, but not all things are expedient. It may be lawful for you to write a will, but it's absolutely not expedient for you to do so. Take this as an advice from your family lawyer. If you need to make a will, talk to a lawyer. It's been a great pleasure spending the past 12 weeks with you on my favorite podcast, Your Family Lawyer. Because of these 12 weeks, I have benefited immensely, and I hope you have too. This episode draws the curtain on these quarters or this season of Your Family Lawyer. I'll see you on the first Saturday of the second half of the year. Until then, stay informed, be empowered, and by all means, be good to your family. My name is Chuma Chinye, and I am your family lawyer.